Building Bridges Initiative appeal entered day 2 today, with the respondent defending the ruling of the Court of Appeal and the High Court to halt the process. Lawyers representing the respondents argue that President Kenyatta failed in initiating a popular initiative, since the move can distract his commitment in serving Kenyans. Josh Onsare has been following the proceedings and has filed the following report.
Lawyers responding to the appellants have continued to defend the High Court and the Court of Appeal ruling on the unconstitutionality of the BBI process, saying President Kenyatta went against the genesis of amending the Constitution.
The President cannot himself legislate. Same way, the proposal by the task forces under the President could have been made and taken up by anyone to pursue a popular initiative.
And the Constitution has been bathed. The individuals in office must exercise the power given to them under that Constitution. Should they seek to alter, they must go back to the people.
If you do not get a million signature, you have not popularized your idea. It is not popular. It only becomes popular when you have collected the signatures of 1 million registered voters.
Activist Isaac Aluochier further argued that the sovereign power rests with the people and not any other arm of government.
Who is boss in Kenya? Is it Martha Koome, the President of the Supreme Court of Kenya? Is it Uhuru Kenyatta, the President of the Republic of Kenya? Is it David Ndii, the champion of the basic structure doctrine, as represented by President Nelson Harvey? Or is it us, the people? In this constitution of ours, we the people are the sovereigns. We are boss.
The respondents' lawyers have blamed the president for involving himself in issues that might distract him from serving the citizens. Lawyers insisting that the president can be sued in his private capacity.
The president of Kenya is not a pharaoh. The president is a servant of the people of Kenya. He exercises delegate executive power, and he must be brought to check if he veers off.
Civil proceedings shall not be instituted in any court against the president or the person performing the functions of that office during their tenure of office in respect of anything done or not done in the exercise of those powers under this Constitution.
Lawyers representing respondent number 20 observed that the Constitution excludes the president, his deputy, among other leaders, from starting a popular initiative, but fails to express how the law should be interpreted in the lower courts, hence asking the Supreme Court to give a proper interpretation.
I urge you, my lords and my ladies, just like the 5 justices of the High Court smelt a skunk, despite it being given a new name.
But it was an invitation to consider whether there were constitutional changes that would be necessary if one was pursuing a measure towards uniting the country. And it is from both reports then that particular recommendations were made to say that yes, there are constitutional amendments that we can make that would help in securing national unity.
You cannot ignore quorum, because if we say that we operate without quorum, then that would be very dangerous, and we know the role that the IEBC plays in our country.
BBI hearing at the Supreme Court enters its last day tomorrow as Kenyans wait for a directive from the 7-judge bench of the court. Josh Onsare, TV 47, Nairobi.